Welcome to this Strategic Legal Explainer. Today, we're diving deep into a massive legislative shift, the 2026 Efficiency Law. If you're a veteran returning resident or a new immigrant looking to maximize your legal tax benefits while strictly managing compliance risks, this briefing is for you. The statutory landscape is changing fast, and understanding the exact mechanics of this new framework is absolutely critical. Let's take a second to look at the sheer scale of this change. Historically, tax exemptions for this demographic focused almost entirely on foreign income and assets. But the 2026 Efficiency Law flips the script. It introduces a temporary, strictly defined tax exemption framework for qualifying income generated right here in Israel. It's a rare, highly time-sensitive window of opportunity. But make no mistake, it comes with rigorous statutory conditions. To help you navigate all this complexity, here is our roadmap for today. We'll start with the impact of the 2026 Efficiency Law, followed by the crucial distinction between qualifying and other income. Then, we'll review some common cases and legal caps, walk through the steps for establishing legal tax residency, discuss strategic planning and pre-rulings, and finally, look at specialized tax representation services. Section 1. The 2026 Efficiency Law Impact, a strict window of opportunity. I really want to draw your attention to the precise chronological boundaries we're dealing with here. To be eligible for this new track, you must establish Israeli tax residency, either for the first time or as a returning veteran, strictly between November 5, 2025 and December 31, 2026. Relocating within this exact window offers the distinct advantage of unprecedented access to domestic income exemptions. But here's the massive disadvantage. The timeline is totally rigid. Execute your relocation outside of these specific dates, and you are entirely disqualified from this particular statutory benefit. Now, for veteran returning residents, the law also mandates obtaining an official certificate from the Ministry of Aliyah and Integration. But please hear this, and it is a vital distinction. Holding this administrative certificate absolutely does not replace a substantive tax residency examination by the tax authorities. The substantive test is what really matters. Also keep in mind, this new legislation doesn't override or cancel your existing exemptions for foreign assets. It essentially operates as an additional parallel framework specifically for domestic income. Section 2, Qualifying versus Other Income, Statutory Distinctions. The statute applies exclusively to what's legally termed qualifying income. From a strict legal standpoint, this means taxable income generated or accrued in Israel specifically through active personal exertion, under Sections 2.1 or 2.2 of the tax ordinance. Simply put, the foundational requirement here is active personal labor performed while you are formally classified as an Israeli resident. We really need to juxtapose these categories, because understanding the line between qualifying income and other incomes is where the real stakes are. Qualifying income is tied directly to your active personal exertion in Israel. Passive revenue streams, capital gains, or non-qualifying corporate allocations, the law explicitly denies the exemption for those. So if income is distributed from a transparent corporate entity, it simply does not qualify unless it falls under very narrow statutory provisions. Assuming all revenue generated in Israel is suddenly shielded is a costly and frankly dangerous misconception. Section 3. Common Cases and Legal Caps. Navigating Statutory Limits. This exemption is built on a temporary sliding scale framework. These statutory caps represent your maximum allowable exempt income per fiscal year. For 2026, the cap is 600,000 Israeli new shekels, calculated proportionally based on your exact days of residency. The benefit peaks at 1 million shekels annually across 2027 and 2028, and then sharply drops down to 350,000 shekels in 2029. Remember, these are absolute statutory ceilings. They limit your exemption, but they certainly don't grant eligibility automatically without meeting all the other legal criteria. And just to put the long-term reality into perspective, by the year 2030, that general exemption cap drops severely to a mere 150,000 shekels. This aggressive reduction really highlights why long-term financial forecasting is essential here. The utility of this specific tax benefit degrades quite significantly over a 5-year horizon. Let's review a very common scenario: income derived from close relatives. Naturally, the legislature anticipated artificial income shifting within families, so they imposed severe limitations to prevent tax avoidance. Between 2026 and 2029, qualifying income from a closely related party is strictly capped at just 140,000 shekels annually. And crucially, this isn't an additional allowance. It is subsumed directly within your overarching general cap. If your professional services involve family-owned enterprises, meticulous legal structuring is going to be non-negotiable. Another frequent case involves individuals operating through foreign corporate entities. You can't just assume that providing services for a foreign company from within Israel automatically triggers the exemption. The income must directly result from your personal exertion. More importantly, the legislation explicitly denies this exemption if you are a substantial shareholder in that foreign entity, or if the entity is classified as a transparent corporation. These statutory disqualifiers require rigorous structural analysis before you even book a flight. Section 4. Establishing legal tax residency. Mitigating compliance risks. The procedural steps to actually substantiate your tax residency are extremely rigorous. Step 1. You must definitively prove that your primary center of life, both objectively and subjectively, has shifted to Israel. Step 2 requires meeting specific physical presence thresholds, literally counting the days spent within the borders. And Step 3 is continuous compliance monitoring. An administrative immigration certificate won't save you here. The tax authority is going to conduct its own independent, highly granular examination of your personal and economic ties. Furthermore, the legislature added severe punitive measures to deter transient relocations. Take a close look at the 75-day rule. If you cease to be an Israeli tax resident during the fiscal years of 2028 or 2029, and you spend fewer than 75 days in Israel during either of those specific years, the law dictates a retroactive revocation of your exemption. This is a massive compliance risk for clients who might treat their relocation as a temporary experiment rather than a definitive structural transition. Section 5. Strategic planning and pre-rulings, preventing unnecessary exposure. So we have to ask the critical question: why is early, proactive tax planning absolutely essential before you execute a 2026 relocation? The answer comes down to preventing catastrophic retroactive tax exposure. Determining the exact start date of your residency, properly classifying mixed income streams, structuring foreign corporate interactions, these are things that simply cannot be fixed retroactively. Once you relocate, post-relocation adjustments are frequently viewed by tax authorities as illegitimate avoidance. The risks here are substantial. Misclassifying mixed income or failing the subjective center of life test can lead to the complete denial of benefits and trigger severe financial penalties. Because of this, it is highly advised to secure formal preliminary tax rulings or pre-rulings directly from the tax authorities. Getting a pre-ruling gives you a binding legal consensus on your tax status and income classification before you expose yourself to liability. For sophisticated individuals, obtaining this upfront certainty isn't just a recommendation, it's an absolute necessity. Section 6. Specialized Tax Representation Services. Unmatched Legal Expertise. This precise domain is the core specialization of Amnon Ben Shoshan & Company. The firm offers premier specialized representation specifically tailored for new immigrants and veteran returning residents who are navigating these exact legislative frameworks. Their expertise covers highly complex tax residency analysis, structuring international corporate activities, and they have a proven, authoritative track record of securing those vital preliminary tax rulings to ensure absolute legal protection for their clients. We'll conclude this briefing with a crucial evaluation of your own position. Is your impending relocation optimally structured to capture these highly restrictive legal benefits? Or are you proceeding with informal assumptions that risk unnecessary, severe tax exposure? The complexities of the 2026 efficiency law leave zero margin for error. We strongly advise engaging expert legal counsel to secure your position, prevent exposure, and truly maximize your statutory rights.